a DWI charge can't be reduced to obstruction of a highway or reckless driving or speeding in Texas because obstruction of a highway, reckless driving, speeding, any other crimes are not lesser included offenses of DWI, right? DWI, you can be convicted of DWI and not have been somebody that was speeding or have been somebody that was being reckless or be somebody that was obstructing of a highway. So those things, they're common. I get the origin of the question. It's just important to note that they're not lesser included offenses. So how do you get there? It depends. The way that we get there for clients is we apply pressure to the elements in the case and the evidence that the prosecutors are going to bring if we go to trial. And by applying pressure, a lot of times we can undercut some of that evidence, and we can start to kind of convince a prosecutor to, on their own, just change the charge and say, hey, we'll do this charge because you'll give up and you'll do a plea agreement if we just change it to this. Anybody watching this video, if you're charged with DWI and the prosecutor is offering for you to take a conviction for speeding, take it. You need to give up and take it. That's worth doing. But you don't get there by clawing at legal elements. You get there by applying pressure and just convincing the prosecutor to come down and do something different. Final note I want to say, a lot of prosecutors can't do this because they have an office policy that says they can't just change a DWI to some other lesser crime, right? And because, again, those are not lesser included offenses, you can't fight for it like that legally if you're in trial.